If you are struggling to follow the developments and the nuances of the Google versus Oracle trial, guess what? You are not alone. The judge, the jury, respective attorneys all have been straining for weeks in this case, looking for some sort of clarity in the tech industry patent wars that is playing out in a San Francisco courtroom. Oracle may or may not get some sort of damages. Google may or may not get some sort of a mistrial. But what's at stake here goes far beyond 9 lines of code. Good morning, good afternoon, everyone. From wherever you are, my name is Jonas Tishner, and this is ZDNet Hot Topics. And joining me to help make sense of all this, we have a panel of journalists who have been in the courtroom and certainly following this trial. I'd like to introduce those first, starting with Dan Farber here, who is joining me in our San Francisco newsroom. Dan is a CNET editor who has also been in the courtroom for several days, very familiar with the players, from ex-Sun CEO Jonathan Schwartz to the father of Java, James Gosling, and CEO Larry Ellison of Oracle, as well as Google CEO Larry Page. We also have joining us Rachel King, a ZDNet editor who has been following this from the beginning, spending weeks locked in a courtroom. Rachel, we appreciate your tenacity during this case. And then we also have Stephen Von Nichols, who is a ZDNet contributor as well as our resident technical expert. I don't want to go as far as to say a guru, Stephen, but thank you so much for joining us today.
Very much my pleasure.
So I want to remind our audience as we get started here, this is an interactive webcast. If you have questions, comments, anything you'd like to bring up during the course of this webcast, we encourage you to do so using the Q&A widget at the bottom there of the console. We're going to take as many of those and reflect on some of your comments before the end of the show today. I want to set the stage here and get sort of a broad view of what we've been discussing. Phase 1 of this trial dealing with Java API copyright claims. Phase 2 dealt with the liability on these patent claims. Phase 1 seemed to go in Oracle's favor. Phase 2 last week seemed to go in Google's, and what the Wall Street Journal described as an incremental victory in this continuing trial. Dan, I want to start with you here. What is your take, and maybe more importantly, which of these phases is more important in the big picture from your perspective?
Well, the phase they just finished was the patent phase. There were only 2 patents involved and not a lot of damages on them, so that was fairly inconsequential. The major case involves the copyrights, and this involves 37 APIs or application programming interfaces that Oracle is claiming Google copied from the Java code. Unfortunately, the jury couldn't come to a conclusion on that, and even if they did, it still probably would have been appealed. The jury found that Google did infringe on the APIs, but it couldn't come to a conclusion as to whether those APIs they were using would fall under the fair use law, which is to say that given there's 15 million lines of code in the Android operating system that Google has created, do these infringing APIs or the other 9 lines of code that a high school kid could have written, do they fall under fair use?
So phase 1, phase 2, they kind of really both are maybe not the most important part of this case. We may be waiting.
Phase one is the API side, the copyright side, and that's the most important one. And we have to wait for the judge to rule on whether copyrights are copyrightable or not. And in any case, this will all get appealed.
Sure. Rachel, on April, actually the start of the trial, I don't want to give a specific date, but I wanted to make sure we use a quote here that you wrote about. You said that it's all but said and done that Oracle is going to have some kind of payday. During a court hearing last July, Judge Alsop admitted that Google is definitely going to pay up, quote, probably in the millions, maybe in the billions at some point. In the same article, you wrote that damages Oracle was looking for have been on the decline. Last September, Oracle wanted at least $1.16 billion in damages from Google. That's been considerably less than $6.1 billion it was asking for in July. Yet some followers of the case have said that Oracle would be lucky to extract even $100 million in this intellectual property suit. What's the latest number being thrown around, Rachel, from your perspective? You even suggested on a blog on May 15th that the number could actually be 0 here.
That's quite possible. Especially now that we know the decision in the patent part of the trial. If you were just focusing on the copyrights, and the judge has said that it's possible the best Oracle could get at this point would be statutory damages for the infringement upon, the jury found infringement upon one count on the 9 lines of code and the range check method. And then the judge tacked on the test files onto that too. And the maximum amount for statutory damages is only $150,000. So it's come quite a long way. And I think a lot of, after the case has played out, a lot of opinions have changed. I'm sure the judge as well, in terms of how much or if any damages Oracle would be able to reap from this kind of trial.
Is that surprising to you, Dan? We're talking about some pretty big numbers, billions, dialing it down now to possibly $150,000. I mean, it almost seems frivolous.
Well, it's not frivolous if you think about Oracle's point of view. So Oracle acquired Sun Microsystems in 2008 for $7.4 billion or $5.5 billion net cash. And a key piece of what they acquired was the Java programming language, which is used on billions and billions of devices as the kind of the language that's one of the underpinnings of how we use the web. So unlike Sun, who decided not to take Google to court over building Android, which was basically a version of the Java code, but done in a clean room, so they could say that, we're not copying their code, we're doing our own. But then there are obviously some pieces where they did copy, such as these APIs and the 9 lines of range check and you looking at some documentation. So Google's a very litigious company. They've recently, sued SAP for $1 billion or more for stealing some of their documentation. On Tomorrow Now, they're in a suit with HP. So they're all over the map in trying to protect whatever they think is their intellectual property. And the other part is they run into a jury where it's incredibly complicated material. I know Rachel can tell you that. I was in the courtroom. I don't know how a jury can really parse this very easily, and I think we saw the result in that they came to a conclusion on infringement but not on the fair use. And then you have the judge, and the judge is really the key player in all this because he's smarter than anybody in the room. And I think he's proven that day after day that he couldn't get rolled over by these high-priced lawyers. Rachel, what do you think about that?
Oh, I completely agree. He was completely on top of everything, did not miss a beat. Even recently, during a proceeding without the jury, but still in front of the public, he was talking to one of Oracle's lead attorneys, David Boies, and and Judge also admitted, before this trial, he had done some programming in different languages, but he started learning Java for the purpose of this trial. And he kind of threw that in Oracle's face in case, they thought they could get around something like that. But he knew, he asked he has questions constantly. The jury did as well, especially when it came to the patent phase. You could really tell that they were trying their best to understand this. But then again, especially when it came to the patent technology, it was beyond most people's heads, I'm sure.
Yeah, we're gonna dive into that a bit more. Stephen, I want to bring you in here to talk a little bit about Java. This promise that you could write once, run anywhere. How important is Java as a product development language today? What do you see as really being at stake here?
Well, there are several different aspects of Java. First, Java as a server language, what used to be called Java 2 Enterprise Edition, that's still pretty important, but it's getting sort of displaced these days by programs that are running, server programs that are running on LAMP stacks, which is Linux, MySQL, Apache, and then Python and PHP, and a lot of different languages. Java really isn't one of those. It's still important in that area, though. It's just not as important as it once was. But then we moved to where Android lives, and which is embedded systems. And Java has long tried to make plays there, but they've always been extremely fragmented. Simon Phipps, who was a Sun C-level officer, talked about that recently, and he said, Java has always been really fragmented in the micro embedded space, and that all that Android really did was thanks to Google's programmers, is that they took the ideas of Java, including the application programming interfaces, and they turned that into a successful product, something that neither Sun nor any other company, Qualcomm comes to mind as someone else who tried it once, have never really been able to manage. So, the bottom line is that in this space that we're talking about, smartphones and tablets, which is where, Google is playing, where Oracle is suing, neither Sun nor Oracle really never made anything like a successful play there. In fact, Oracle didn't try to make a development play there at all. They immediately moved to litigation to try to monetize the billions they had spent on Sun. Google in the meantime had taken again those basic ideas and the APIs, put them in a clean room, reversed engineered them, and came out with what you could argue is the most successful smartphone and tablet operating system in the world. So I guess to get to the real answer to the question is, Java has never really mattered in this space, but Google's Android spin on Java has turned out to be enormously important.
So you have a blog that you've put together some pretty interesting comments. One of them, the title was the muddled mess of the Oracle versus Google trial. Expand on that a bit for us, including your take on the copyrightable APIs. I mean, you've basically said no winners, no losers in this case.
Well, actually, I think that there has been a loser, and that loser, now that all said is done, is Oracle. Now, it is possible that Judge William Alsop is going to rule that APIs can be copyrighted. In that case, everything changes. Oracle probably would win, but then when I say everything, I mean everyone who does anything with any programming languages, because all software is written with these various languages. We've never thought of APIs as being something you could copyright before. That opens an enormous can of worms, which would be appealed. And I really doubt that that's going to. I really doubt that he will rule that way. And if he does rule that way, that it would end up holding up. Still, that being the case, Oracle in the short term would still win there. But I think, again, it's unlikely the judge will do that, so I think Oracle is really going to lose on this. I think Oracle has invested tens, perhaps hundreds of millions of dollars into this lawsuit, all in an attempt to monetize their intellectual property that they bought from Sun, and I just don't see that they're going to be able to do it. What patent claims are left are really quite minimal, even by Oracle's own patent experts. They think that the patents are worth at most $32.3 million. I mean, that's a lot of money to you, and it's a lot of money to most of the people listening to us. But for companies like the size of Google and Oracle, that's almost petty change. And as for copyrights, again, short of the APIs situation, Oracle was going to get, again, 40,000 out of it top.
Yeah. Rachel, you mentioned something, and Dan will talk about this too here, but I wanted to bring up something that Rachel wrote about, that this trial is very difficult because of the technical aspect of it. Rachel, a couple quotes from a blog that you wrote here. You said the evidence in this case was extremely technical and tricky, especially when it came to the patent phase. The jury screened to exclude anyone who had any technical background. On the one hand, that offers the potential for a more objective jury. On the other hand, it leaves them terribly confused, and by the tail end, it actually became more like watching a horror movie, as the audience, the press, the public, the courtroom knew so much more about this trial and where it was headed. Regardless, the jury had no idea. So this put the jury and the judge, frankly, in a bit of a tough spot. We'll start with you, and then I want to get Dan's take on that.
Sure. In reference to the horror film, there were a lot of things the jury just didn't know in terms of the timing, the roadmap for the trial. For example, they weren't aware that, and rightfully so, they weren't aware that if they came to a non-guilty verdict in favor of Google on the charge, they could go home immediately, because the judge had already previously ruled that after the partial verdict and Google's motion for a mistrial, it became clear that they could not that they would need a new jury to go forward with the copyrights, no matter what happens at this point. In terms of the two patents in question, a lot of it had to do with the Dalvik and the differences between the Dalvik virtual machine, which Android runs on, and the Java virtual machine. And it came down to the bytecode and different technical terms for, depending on how you look at it, whether it's the same thing or different processes. Both sides had a lot of experts throwing terms around, and even I believe it was Oracle's lawyers who commented, actually most programmers don't even deal with bytecode. It's mainly engineers. So, and for the jury to take a crash course on this in about span of less than 2 weeks, it's almost mind-boggling. It's hard enough for the experts to explain it, let alone for them to completely comprehend it that quickly.
Dan, anything to add on that technical aspect? Just sometimes watching the glazing over as these technical things got pushed around.
Well, as Rachel said, it was very technical at different points, but the jury was actually quite attentive, or at least they appeared to be so. But the days I was in the courtroom, it was often like a computer science classroom where you had experts and $800 per hour lawyers going up to whiteboards and explaining, well, this is how an API works, and this part is copyrightable, but this part isn't, and this is creative, and this is just the stuff that everybody can use. And so it was quite hilarious at times to see the courtroom just kind of filled up like a Stanford classroom.
You've written, Dan, about the people, the personalities in this case involved in the trial. Can you describe a little bit about what struck you? We know that Google's Larry Page arrived by himself on days in a taxi, whereas Larry Ellison, and an entourage seemed to enjoy dodging the press, including our cameras. Talk a little bit about what struck you in terms of the personalities.
Well, everybody played their part. Larry Ellison was, as he has always been, quite forthright and extremely competitive. And Larry Page was in his element as well. So there's no surprises there. I think the surprises actually come when the lawyers start grilling the people on the stand. And in the case of some of these engineers, for some reason, they just couldn't remember what happened 4 or 5 years ago, despite the fact that these emails were very explicit. My favorite part of the whole case was when Tim Lindholm, who was one of the key Java engineers at Sun, worked, and then he went to Google, where he supposedly just helped out on Android but wasn't part of the team. He wrote memos, for example, one as late as 2010, saying, Larry and Sergey asked us to go look at alternatives to Java for what we are doing, and we found that they all suck, so we think we need to get a license for it. So he said, we think we need to get a license. So Google's lawyer would ask him, well, you think you needed to get a license? Well, a license from whom? I don't know. Was it from Sun? No. So you had these engineers and executives dissembling or saying what they wanted on the stand. But I think the key for the case was when Jonathan Schwartz, the former CEO of Sun, got on the stand and said basically, well, we were fine with what Google was doing.
Rachel, it's been said that Larry Ellison certainly likes a fight, and squeezing money out of companies like Google that create their own Java-like programs was part of his plan, to the point that Dan's making. When they paid $7.4 billion for Sun, what's your take on that?
Well, as far as it depends on your opinion or who you talk to, because it's arguable that a lot of people have argued that Oracle bought Sun for litigation purposes. Then again, during the trial, it was brought up that Oracle was looking forward to working with Google on Java and Android related projects. So a lot of it just a lot of it was like evasiveness on the stand. Came down to like, who is the jury going to believe more, really, at the end of the day.
Well, part of it also was, the amount of money that Sun or Oracle could make from Java wasn't that much. Maybe it was, I think at its height for Sun, it was probably around $250 million a year.
About $250 million.
And yesterday, Larry Ellison, who was at the All Things D conference, said that Sun is enormously profitable for the company. So I don't think it's necessarily about the money. I think it's more about extracting an annuity from the Java code, from that could last years and years.
Stephen, we're getting a follow-up question on a discussion here. Wouldn't this is coming from Timmy saying, wouldn't the companies using this similar or identical code benefit from them even within their own company, or does this not really play a factor?
I'm not quite sure I understood the question. What code is he talking about?
Well, I think he's referring to the Java-like code.
Still not quite sure where he's going with that. If he's talking about, first, Java was open sourced. Now, you can argue over exactly how they open sourced it, but bottom line is, under McNeely's rule, Sun finally said, you know what? Using this in a traditional proprietary way isn't looking for us. We're going to open source. They did so under the GPL version 2. So in theory, you can use Java yourself today and write your own programs. Now, it's a little bit trickier than that for reasons that I'm not going to bore anyone with. But, essentially, Sun already gave people permission to do what they wanted to with their code, build their own programs, and not have to take a license out. Again, Oracle would argue, but for the kind of things that Google did, you had to have a license. You can go around and around with that. But by opening it up, Sun was hoping that other people would do more interesting and productive things with Java. And in a way, actually, they were right. Google did something very interesting with Java on micro devices, and what they did was they created Android, which again is also open source, so not as open as some people in the open source community would like it to be.
So this is kind of a broad question. Dan, we'll start with you. Where do we go from here? What do we kind of look at as the next phase of this trial? What are we going to be considering, and what implications does that have?
Well, the only interesting part of this is now for the judge, William Alsup, to determine whether he will rule on APIs being copyrightable or not. Now, he could narrow it down to just be the APIs in question here and not the APIs of the universe, because that would actually basically be saying that not all APIs are created equal. Some may be so creative and so intricate that they could be considered creative works that should be copyrighted, whereas others could be very straightforward. But whatever, if the APIs are ruled to be copyrightable, that opens, I think, as everybody said, a big can of worms, because any developer is going to have to be thinking about, well, who do I have to pay now to create my software, given that the purpose of APIs is basically to allow people to get different pieces of software and devices to talk to one another. And that people tend to just reverse engineer those APIs so that they can use them themselves. So it would create a great deal of consternation in the software industry.
Rachel, you agree with that? I see you guys nodding your heads.
Mm-hmm. Recently, in the European Commission actually just had a similar case, ruled that APIs are not copyrightable, and the judge has asked for a lot of advice, a lot of briefings on that case and other cases to help him with his decision. In terms of when we're going to find out, it could be this week, it could be next week. We thought earlier this month it might be at that time. We also he still has to decide over the motion for, after that we would find out if there would be, if Google would get its motion for mistrial approved or not. Yesterday, he rejected a motion from Oracle asking for a judgment as a matter of law as to whether or not to overturn the jury's verdict on patents, but he denied that. So the focus again really is on the copyrights.
Yeah, Stephen, obviously we're going to be waiting here to find out what's next. A bit of tea leaf reading. What impact do you think this is going to have on Java partners out there, if any?
If I'm a Java partner, I'm worried. I'm worried because I'm wondering, is Oracle going to demand even more for my licensing fees when they come up for renewal if I'm in a licensing arrangement with them? I'm going to worry, is Oracle going to come after me next? I'd be very concerned about that. Oracle also likes to talk about how they're defending the Java community and so on. And so far, no one thinks that they're really doing that good a job of defending the community, whatever the heck that means in 2012. To give a little bit of history here, Sun created Java and then shared it out with a lot of other companies in something that was called the Java Community Process, in which sort of like Java was chairman of the board, and other people could say, well, we'd like to do this with Java, or we'd like to do that with Java, and they would then debate about it. But at the end of the day, Sun always got to make the final call. So you always had sort of a weird relationship between Sun and its partners. In some cases, some of those partners went off in different directions, like IBM did when it came to the developer interfaces, and they decided that they would rather go with something called Eclipse rather than NetBeans. All of which is now ancient history. But there's always been sort of this splitting apart and coming together again in Java. And I think those Java partner nows really just have more reason to be concerned about exactly what's going on and what it's really going to mean for them going forward with their Oracle partnerships.
Dan, kind of running out of time here, but do you see any new burdens that technology companies are going to be facing in the wake of this trial? I mean, we've talked a lot about intellectual property and this sort of thing, but do you see some burdens that technology is going to be facing as a result of this, that we're going to look back, at June 2012 and say, here was the impact on the technology world based on the outcome of this trial?
Well, it is a bit of a strange time. There's a tremendous amount of innovation going on in the internet and in the social web and even in enterprise software. But at the same time, there's a kind of maturing theme going on, which is companies who are going to patents and copyrights as a way to generate revenues. Now, that's not to say that they don't have a good case to make, which is this is our intellectual property. If people want to use it, we spent the money to create it, and we should be paid for it. But it's gone to a great extreme, and where you see all these companies buying up patents. Google spent $12.5 billion buying a lot of patents from Motorola recently. Apple, I think, and Microsoft bought up $4.5 billion worth of Nortel patents, and this goes on and on. Then you have Samsung and Apple in court over patents. And so we're in an age where intellectual property has come to the foreground, but the patent laws and issues around copyrights and APIs, for example, they're still not fully rendered in a way where people have a good understanding. I think the people who get most hurt in this situation is the smaller developers who really can't afford the fees, or an entrepreneur who just wants to create something in their garage. The bigger companies, less so. I mean, how much more are they going to be charged to license some APIs if that's the case? Not a whole lot. But it will impact people who are less well endowed with cash.
Do you buy into that, Stephen?
Yeah, I do. I think that for several years now, patents in particular have been used as sort of clubs, particularly on smaller companies. It's used to, and by patent trolls, use it to just extract money from these companies. They'd rather fighting patent litigation. If someone sues you in a patent lawsuit, it's expensive to defend that. It's very expensive. It's often cheaper just to pay them off, and that's what patent trolls do. In the case of bigger companies like Oracle and so on, it's a matter of exerting power over each other. Google bought Motorola, I think we all pretty much know, for its patents, and it bought those so it could defend itself against Apple and Microsoft in future telecom-related patent issues. And and we're talking billions of dollars. I mean, these companies even companies this size feel the impact of that. And all of that is money which could be better spent on innovation, on engineering, on development, and instead it's being fought over extremely fine points of patent law about patents which frequently are found not to be that good in the first place. I believe Oracle actually started its Google lawsuit with 8 or 7 patents in their pocket. When the push finally came to shove, though, only 2 of those patents had survived. The others had been knocked out by the Patent Trademark Office and by other people looking at them and saying, you know what, yeah, these patents were granted, but they're bad patents. They never should have been granted. And and the end result is we're just spending a lot of money and a lot of time on these legal exercises, which are very frustrating, don't do anything for getting products out, certainly doesn't do anything for customers or end users. A number of years back, Ray Norda, who was the founder of a company called Novell, which in its day was the networking giant, decided that he was not going to have a lawsuit over the Unix operating system, saying he thought it would be better to compete in the marketplace rather than in the courtroom. I just really wish that in our current technology business culture, we had more leaders like Norda was, who decided it would really be much better to fight it out and to try to win business in the business place rather than in the halls of justice.
You see that going on now with Yahoo and Facebook. So
Yeah.
Yahoo has a bunch of patents. They sued Facebook. Facebook had some patents. They acquired a bunch of patents from IBM. They'll probably get some others. But to a large degree, a company like Facebook or even Google is doing it for defensive purposes. Their goal isn't necessarily to charge people. It's to protect themselves from being charged.
Yeah. Gentlemen, I appreciate you being with us. Dan Farber here in San Francisco, and we appreciate you via Skype, Stephen Von Nichols. And, of course, Rachel, we thank you as well. And I know you guys were going to be following this until the very end, so we certainly do appreciate it. You've been watching ZDNet's Hot Topics. We've been discussing Google versus Oracle trial. This presentation will be available in its entirety on demand in case you'd like to watch it again or missed anything. And we invite you to join us again next week when we have another ZDNet's Hot Topics. My name is Jonas Tishner. Thanks again for watching.